we also need to talk about Justice Kagan's appeasement energy. I don't know if maybe that's not the right thing to call it, but I will just note that there were a number of cases decided on a 7-2 fracture because Justice Kagan joined the conservatives. So RGR Vapor was one, Diamond Energy, Stanley versus City of Sanford. Any theories as to why Justice Kagan left Justices Sotomayor and Jackson out in the cold on these cases? And I will also note that these were some of the cases where Justice Jackson penned her most stinging dissents against the majority. What's going on here? Is Justice Kagan extracting compromises for her vote? I don't think her vote makes much of a difference with a 7-2 fracture. I mean, they're fine without her. What's going on here? Is this just sort of more appeasement? That's what Micah Schwartzman at UVA has called it in the context of the First Amendment. I'm confused.
I really don't know. I mean, Justice Kagan authored the non-delegation case, FCC versus Consumers Research. It's just hard to know, what is going on behind the scenes. And I think I've said this before, and it's something we've talked about, but it's so hard to know the internal dynamics at the court and the extent to which the Democratic appointees or any Democratic appointee feels like, if I peel off more or all the time, are these guys really going to go even full on crazier in more sets of cases? Like, they truly are enough snowflakes where that's not impossible for me to imagine. And I don't know how to strike the right balance. Diamond Energy, that case is one where Steve Vladek and I talked about this in the episode you all unfortunately had to miss. Like, we are both sympathetic to broad theories of standing. So on the merits, I think they are probably right that there is standing. I think their decision to decide the case is appalling and is revealing of the kind of selectivity that Justice Jackson rightfully criticized them for, including on standing doctrine. But yeah, I don't know.
And I'll just say, I think she's a very kind of careful and tactical thinker and writer, and it is entirely possible that she, through the process of, draft revisions that circulate inside the court, she was able to extract some concessions where language she thought would be destructive in other areas of the law, and she was able to sort of smooth those over or get them actually taken out. So certainly, she may have made these one-off decisions that I think in the aggregate, it is a little hard to understand, but on an individual basis, actually may have been totally rational and helped blunt the negative force of some of these opinions.
Hear me out. I just worry that appeasement is not really a strategy here. I'm thinking back to Justice Breyer in Trinity Lutheran, Justice Kagan in Town of Greece. That did not forestall the flood of absolute asshat decisions on the First Amendment that the court produced. And I'm also thinking of her joining the dissent in Ramos. When was that? Back in 2019. And I understood then, I think she telegraphed pretty clearly that she was joining them in order to make a point about stare decisis and the continuing vitality of Apodaca versus Oregon, a decision decided in 1973, the same year as another embattled decision. And that still did not forestall what happened in Dobbs.
It didn't forestall it. As we've kind of speculated before, it might delay some of the impending doom.
We got a good 3 years out of that.
Three more years of the Establishment Clause. Again, I don't know. And, I am also super skeptical of the appeasement strategy. It is not obviously where I lean. And I do think this difference in the justice's posture relates to another thing that was said on the episode with Steve that I was mentioning. And that's something Mike Sachs said, which is Justice Jackson as the model of the post-Dobbs justice who recognizes that appeasement fails. And that is not the strategy. You need to construct and build something new and advocate boldly for an alternative vision.
Let me say what I'm going to say what I mean plainly then. I think this appeasement strategy in this particular moment where it's a 6-3 court and there are 2 women of color among that minority and you are the third person and you're not a woman of color. I think when you depart, even on these cases that look not so consequential but are actually quite consequential, you leave the other 2 open to tons of charges from the conservatives about the stupidity, the lawlessness of their reasoning, when if you join them, you could insulate some of that talk. And I think, I'm not sure that the appeasement is worth what you're losing.
That's a super great and important point, because I feel like in some ways what you're saying is that Justice Kagan might be ignoring some important context, right, in which the court is deciding cases, in the same way that the Republican justices in the supermajority ignore the context of the Trump administration, right? And like not situating your decisions in the moment we are in, right, is...
I wouldn't say those are comparable, right?
No.
Yeah. But for sure, like there are real costs involved. And I think, Melissa, you highlighted those really, really well.